We're here for sentencing. Is there a statement from the state of Ohio?
Your Honor, as you're well aware of this case, the defendant was offered the same offer that the co-defendant pled to, like mid last year, in the fall of last year. That was Randall Caldwell. That was 3 to 4.5 mandatory, because the F2 is a mandatory prison sentence. We couldn't offer the minimum because both of them had horrific sentences. This defendant especially had an even worse sentence history than the co-defendant did. However, the defendant chose not to take that offer. We had a motion to suppress in this case, then we set it for trial. Sorry. And a couple of times, and then he pled to the indictment with no agreement on sentencing. And that he pled last November, and here we are 4 months later, and we're just sentencing him. And quite frankly, based on his history, not only the criminal history, but also his inability, even while in prison, when he was in prison, he was not able to follow the rules and had numerous infractions while in prison. We're asking that he serve at least 5 to 7.5 years on count 2, and then we can run count 3 concurrent. Or actually, considering that he brought that into TCC, I'd ask that like the 9 months on count 3, the illegal conveyance, be run consecutive to that.
Okay, thank you. Mr. Bogan, anything on behalf of Mr. Edwards?
Yes, Your Honor. First, if I may approach, I have a... Here, Teresa.
Did you file the affidavit of indigency?
Oh, wait, I need to do that. You're right.
Because we have a mandatory fine as well.
Yeah, I forgot. Could you put up an affidavit of indigency for me, please?
And also, there's 10 days of jail time credit, Judge.
10? Okay,
10.
thank you.
But, Judge, you obviously see he's got a bit of a history, but this is the kind of history I think we see a lot more times than we can count, where it's a bunch of offenses that were feeding an addiction. And where does his addiction start? Well, he was, he's born in 1980, started his addiction at age 21. Where did it start? His right finger was almost completely severed, and he was prescribed Vicodin. And Judge, unfortunately, I think we've seen with all those payouts by the prescription drug companies who originally said these drugs were safe, well, unfortunately, we're seeing the effects of that. But that's where his addiction started. And he was doing this to support a habit. And the thing here that makes this case really sad, what he did here was in exchange for $200 to $300. $200 to $300. And you see also, according to Talbot House, he meets the criteria for PTSD, which, as you know, mental health and drug issues both make each other worse, dual diagnosis. And I think that ties into the Social Security issues that we had brought to your attention. But while this case has been pending, it appears that he's been compliant with bond, has not tested, and he is, I can't think of any recent positive drug tests, and he had been doing laundry at UniFirst Uniforms. He knows he's got a lot of work to do to deal with his habit. He's been laying a foundation while this case has been pending. And Judge, obviously, there's been a lot of damage done early in that he's going to have to deal with, and he knows he can't deal with it by turning to drugs.
Mr. Edwards, is there anything you'd like to say, sir?
Yes, sir. When I first came in here on this case, you looked at the prosecutor and said I would never change. Sir, like I have changed. I work. I take care of my family now. Like my child support, I owe like $400 more on my child support, and I'm paid off on it. Like I don't mess with drugs. I'm on the MAP program. And my prison, when I was getting in trouble in prison, that was because of Suboxone, trying to get high. But I'm on the MAP program, and I ain't felt no drug test. And like I do have something, like I'm trying to prove everybody. Like I know I have a past, but if you can look at the time where I've been out on bond, all the good stuff that I have done for myself, like you said, laying the foundation.
Tell me when you're done, because you paused and you start.
I'm sorry, I'm done. I'm just nervous.
Okay, I understand. I didn't want to cut you off. So your attorney says you injured your finger, started taking Vicodin, and here we are today, right?
Yes, sir.
You were stealing at 18 years of age, 1999, right?
Yeah.
Okay. That's when a lot of people your age went in the military and went and fought in Iraq.
Yeah.
And they know what PTSD is. And many of them also came back and had surgeries and got addicted to pain medication and had many rough years, but they're dealing with it.
Yes, sir.
It sounds like you're starting to deal with it. The problem is you left a lot of victims in your path as well.
Yes, sir.
So, if you're doing better, great. But you got to deal with these
sir.
situations here. On felony 2, aggravated possession of methamphetamine, count 1, the sentence is 3 to 4.5 years. On count 2, illegal conveyance of drugs of abuse onto the grounds of a specified governmental facility. The penalty is 36 months. Those two are to run concurrent. You have an indeterminate sentence. It's presumed that you'll be released from the service of your sentence on the expiration of the 3-year prison term or your presumptive earned release date, whichever is earlier. The Department of Corrections may rebut the presumption if at a hearing the department makes specific determinations regarding your conduct while confined, your rehabilitation, your threat to society, your restrictive housing, if any, while confined, and your security classification. If the department makes the specified determination and rebuts the presumption, the department may maintain your incarceration after the expiration of the 3 years or the presumptive earned early release date for a length of time the department determines to be reasonable, subject to the limitation requires release at the end of the maximum term. The department may make these determinations and maintain your incarceration more than one time, but they must release you no later than the end of the maximum term. If you've not been released prior to the expiration of the maximum term, which is 4.5 years, then you must be released upon the expiration of that term. The important thing for you to remember is you can get out in 3 years or any earned early release date, or 4.5. Your conduct in prison will determine whether it's 3 or 4.5. You've had a lot of trouble following rules in your life. You've made some effort to change that.
Yes, sir.
If you're written up, if you're possessing drugs, anything like that, it's an extra 1.5 years. This carries post-release control, which is supervision by the adult parole authority. If you violate the terms of post-release control, the adult parole authority can send you back to prison for 9 months per violation, up to 1/2 of your stated sentence. If you commit a new felony while you're on supervision, the court that has a new felony case can revoke post-release control, impose whatever time remains on supervision. If you have less than a year remaining on supervision, they can add a year to the sentence in the new felony. What is this 2-year post-release control, or is it more?
No, I believe it's the 2-year, Your Honor. 1 second. It's up to 3 years, but not less than 18 months.
Okay, so post-release control, they can supervise you for up to 3 years but no less than 18 months, meaning they have to supervise you for at least 18 months, and then it's discretionary. You have a right, waive the mandatory fine. Is there anything else I haven't addressed?
And costs as
And
well?
costs,
Okay.
late costs.
As long as that, did you sign the affidavit?
Yes, I saw
Okay.
it.
Oh, you did? Okay, I'm so sorry. I didn't know he had given it to you. Nothing more then, Your Honor. Thank you.
Mr. Bogan, anything else?
Nothing else, Judge.
Mr. Edwards, do you have any questions?
Oh, so there was a phone in evidence on this case. How can I get that released?
If they determine that it was used to commit a crime, you may not get it released, but your attorney can tell you how to get it released. Basically, you ask the people who took it, whether it's the parole authority, whoever took your phone, that's who you need to request the return of the phone from.
Okay. Is there any way,
Prosecutor may have some information on that.
is there any way I can hug my aunt before I leave?
Unfortunately, you should have done that before you came in.
All
The
right.
sheriff's got rules.
All right.
You have a right to appeal this sentence. You have 30 days from today to file a notice of appeal. If you can't afford an attorney will be appointed to represent you. Any document you need will be provided at no cost. All right, that's all. Thank you.
Thank you, Judge.
Under Ohio Revised Code Section 2925.11, aggravated possession of drugs prohibits knowingly obtaining, possessing, or using a controlled substance, including methamphetamine, and is classified as a felony of the second degree depending on quantity. The related offense of illegal conveyance of drugs into a detention facility arises under Ohio Revised Code Section 2921.36, which criminalizes knowingly bringing controlled substances into a correctional institution. In this case, before the Court of Common Pleas, State of Ohio, the defendant entered a guilty plea to the indictment without a negotiated sentencing agreement, leaving the court to determine the appropriate penalty after review of the pre-sentence investigation report, criminal history, and mitigation presented by the defense. The court applied the statutory sentencing principles under Ohio Revised Code Sections 2929.11 and 2929.12, including factors relating to the seriousness of the offense, likelihood of recidivism, and the need to protect the public. The court imposed an indefinite prison sentence of 3 to 4.5 years on the aggravated possession charge, with a 36-month term on the illegal conveyance charge to run concurrently. The sentence includes post-release control supervision for a period of 18 months up to 3 years, as determined by the Adult Parole Authority, with additional penalties for any violations following release.